All right.
Okay, just let me know when you're ready for me to get going.
We are recording and you can take it away, John. Thank you.
Awesome. Well, first of all, thank you, Kate, for giving us this opportunity. Just so everyone knows, I am an attorney, but first and foremost, I am the father of Anthony. He's my son. He's 34 years old. He has autism, and he's the reason that I got into legal planning. He was one of those uh, I guess, the catalyst, if you can, that really kind of set me on this whole path in life. And so I'm really excited to start sharing with you guys some of the things that I've learned along the way and tell you a little bit about what we do and how it can affect you in your life. So, with that, I'm going to go ahead and share my screen and we're going to get started on the presentation. And throughout the presentation, I will share a little bit more about myself. So you all should be seeing the title slide. It says legal planning for the care and custody of your family member with special needs, navigating the special needs journey. And so I don't have much time. I'm going to move fairly quickly through some of this, but I do encourage you to if questions come up during the presentation, don't hesitate to throw them on the chat and just get them out there. If it's something that I can stop and address really quickly, I will. I've left time at the end to take questions, so if I don't interrupt what I'm saying to get to your question right away, we will go back into the chat and we'll try to address as many questions as possible before we leave. And if you have access to chat, I'm going to ask you to go ahead and just get started right now and put some information in the chat about yourself. The things that I'm really curious to know about are how old is your child? I'm assuming most everybody on the call has a child with autism, but you may have other situations in your life. So how old is the child that has autism or any other condition that drew you here today? And what is their primary diagnosis that you're dealing with? It just kind of helps me to know who's in the audience and if I can address anything specific, dealing with any other situations or dealing with specific age groups. I want to make sure that I do that. So if you're not driving, if you're sitting in front of your computer or in front of your phone or your iPad or whatever you have in front of you, if you take a moment, go ahead and throw it in there and we'll take a look. Kate, thank you so much. You have an 8 and 12-year-old who are both autistic. Thanks for sharing that. And I'm going to go ahead and get started. I'm keeping an eye. Tamara, you have an 18-year-old who is autistic. Thank you for sharing. So you don't need to see that picture. You've already seen me. Let's talk about my son just for a moment. This is Anthony. He's 34 years old and just the greatest kid. We all think that, right? Well, we have great kids. Great sense of humor. He's obviously challenging. He has not only been diagnosed with autism, but has other really challenging diagnoses as well, physically and intellectual. And so he's been I look at it that it's an humbling blessing that basically God gave me Anthony to teach me a lot about life and to make sure that he has the best life possible. And so I know you all feel the same way about your kids, and if you had the chance, you would we could all sit down and talk for a couple hours just about our kids. So Anthony, though, he's the reason that I got into special needs planning. He's, I was a flight paramedic for 20 years, and I would remember like flying around in a helicopter and in airplanes, and thinking, if we crashed and something happened to me, where would Anthony end up? And all I could come up with were the worst case scenarios of, would he be in, some kind of a institutional setting? Who would be caring for him? Would it be someone who really didn't, know and understand Anthony? And you guys all know our kids have such unique characteristics and things that drive them and motivate them. And would it be some minimum wage worker just making Anthony get up at a specific time and go to bed, and 15 minutes for a shower, and all these things just would go through my head, and I was just terrified of what would happen to Anthony if something happened to his mother and me. And so I sought answers. Now this was 20, 30 years ago. We didn't have the internet. We didn't have access to the information that we have today. And I didn't have an autism society that I could go to and say, hey guys, I need some help. I need some resources. And so I went to friends and family, and I got a lot of information that I didn't know what to do with. Make sure you don't, you just inherit them from your will. You need a trust. You need life insurance. You need this. And I didn't know what to do with any of the information. And so for years, I lived with that hanging over my head, and what would happen and how can I fix it. It wasn't until I started working with some estate planning attorneys that I discovered that there were answers. And I asked these attorneys, like, can you help me? They're estate planning attorneys. Can you help me with a plan for Anthony? And they'd all say, oh, sure, we can do a special needs trust or whatever. But what I discovered is that although there were a lot of estate planning attorneys out there who claimed to be able to help me, they didn't really understand how to plan appropriately for Anthony, and how to turn that plan into an overall life plan for Anthony. And so I spent thousands and thousands of dollars and hours of time learning it and researching it, because nobody else seemed to be able to do what I wanted them to do and put the plan in place that I wanted. And so, I read every book and white paper, and I went to conferences and boot camps and everything I could, like, how do I do this? And when I finally wrote up my plan and a plan for Anthony, I got to tell you, the weight that lifted off my shoulders, it was just so liberating that it became very clear to me that the reason that I'm here is to share with other people my experience, and to make sure that other people have the same experience that I did, and get that same experience.
For 15 minutes of savers.
I'd like you to go too, Brian. Dad's limits.
So Sheila says she cannot hear. Is anyone else unable to hear? Can everyone hear me okay?
I can hear you okay. Phyllis,
Okay, thank you. All right. So I'm going to keep going, Sheila. I hope you can get that figured out so that you can hear. And I'm going to keep moving forward. I would ask that everybody keep their microphones on mute, just to eliminate background noise that might come through. So when I first started this journey, guys, this is kind of the way it looked to me. Everything was kind of foggy. I didn't have any real clear idea where I was going. I just had to put one foot in front of the other, take it one step at a time, and see what was around the next corner. And today, this is how I see that journey. I did it for myself, and I've helped so many other families go down this path that now I take the role as the guide who's been down this path before, and I know what to look for. And my goal is to not have people have to go through that same journey that I did and not know what's around the next corner, but to have clear vision of what to expect and what's available and how to achieve that for their families. So just going to throw this in here real quick. If, my promise to you today, guys, is that I'm not going to do anything to waste your time. I'm going to give you as much information as I can to help bring some clarity into your lives and the planning for your children. And because my mission in life is to educate and inform families of children with special needs of what's available and how to achieve that planning and that peace of mind. I offer a 2-hour special needs planning session, and I offer that at no charge because my goal and my mission is to make sure that people have full information and education to be able to make decisions from a standpoint of empowerment and knowledge. And so at the end of the presentation, I will let you know how to take advantage of that free session. Very quickly, just a couple of referrals. Dave, father of a beautiful girl with autism, he told us that we owe you all the thanks for helping to ease one of the many big burdens in life. It's exactly the way I felt when I got this done. And then, this is a single mother. Thanks for all you've done for me. And I can't tell you how secure I feel having all in place for my loved ones. So these are just two samples of the comments and feedback that we get when parents of children with special needs of all ages get this planning in place, and they realize that, wow, it's done. And I can see clearly everything that I had doubts about and concerns about. So very quickly, I want to tell you, this is my family, and my wife's up here on the left-hand, top left-hand corner. We are a blended family. We have 5 boys, and you can see Anthony's on the bottom left. But our other 4 kids are all married and have children of their own. And the reason I do planning, the reason I have a plan in place for myself is for them, is to make sure that if something ever happens to me, these people have the right plan in place for them. And recently we learned one of my sons on the bottom right-hand corner, that's Jake and his wife and son Maverick. And we've learned that Maverick has some developmental delays, and they're doing extensive testing to try to figure out what is going on with him. And so there's another generation there that I'll be able to step in and make sure that Maverick is taken care of, and that Jake and his family have everything in place. So this is my reason right here, this beautiful family. So let's talk about you guys. Now, you guys will probably recognize some of this. This is the life cycle of a typical family with a member with special needs. And I know a lot of people, the reason I say a member with special needs is because we have a lot of clients who come to us with who are aunts and uncles or nephews or siblings of individuals with various diagnoses, and they've ended up having to adopt them or raise them or be in charge of them for some reason. And so it's not just children. We have a lot of different family dynamics. But you guys probably remember back to the day when your child was diagnosed, and you had to rely on support from family and friends to get through that initial shock and kind of reset for the future and what your future was going to look like. And then you have to you go through this process of trying to work with the DDD, and you're trying to get benefits for your child and make sure that they have everything in place that they need to for their medical care and other services. Then they end up in school, and now you're dealing with all of the school issues and the IEPs and the frustrations that goes along with that many times. And at some point in the life cycle, you realize that your child is reaching adulthood, and you have to start thinking about guardianship, and is it right for my child, and do they need it, and what happens if I can't be their guardian any longer, and am I the right person to be their guardian? And so all these questions around guardianship come up. And at some point in that cycle, the realization also hits that, my child is dependent on me financially. And how can I ensure that even when I'm no longer around to provide for them, that they have what they need in life, to maintain a quality of life and to have the resources that they need available? And how can I provide for them financially? So this is just what we see. This is true in my life. This is what we see in many of our clients who come through this. There's somewhere along this spectrum in the life cycle when they come and talk to us. But what a lot of people don't actually stop to think about, and we're going to talk about it today, is, I have a minor child who may or may not have autism or some other diagnosis. What would happen to my child or my minor children if I became incapacitated and died? If my child was left without a parent, what would happen and where would they end up? And what we know and what we're going to talk about here in a moment is that way too often this ends up with a child being in the care and custody of a stranger, getting into the system, the Department of Child Services, having to take guardianship of the child and place them in a home of strangers. And this to me is absolutely, it was my biggest fear, and I find it unacceptable. So a big part of our planning is making sure that you never have to deal with that. And so with that, kind of the foundation of today's talk is 3 fundamental agreements that I think everyone who's on this call can really get on board with. I don't think there's anything here that anyone would say, yeah, no, that's not important. Those 3 agreements are that my child must never end up in the care or home of strangers. Whether they're a minor child or an adult, they should never have strangers taking care of them or having to end up in their home. The second is that my child will need additional financial support when I become incapacitated or die. What we know today is that with medical advances and all the technology that we have, more and more our children, even with the numerous diagnoses that are out there that lead them to need additional help, are outliving us. There was a time when if your child had, Down syndrome, for example, the average lifespan was 25, 35 years, and we prepared ourselves to outlive our children and deal with that. Now we're finding that our children are outliving us, and we don't have the liberty anymore of saying, well, I'm going to put my child through college and then they'll be independent and they don't need me anymore. Our children with autism and other diagnoses are going to be reliant on us for the rest of their lives, not ours. And so how can we ensure that when we're no longer able to provide for them, that there's a plan in place to make sure that they are provided for? And then the third agreement is that my child must never involuntarily lose eligibility for benefits. And through an error of my own or through something a family member has done or anything like that. So if there's anything on those 3 fundamental agreements, because those are the foundation of what we're going to talk about today, if there's anything there that when you look at that, you're like, no, John, I don't agree with that, I would like to throw that in the chat and let me know, and we can bring it into the discussion. So in dealing with these 3 fundamental agreements, basically the way I approach this planning is that, it's like a pyramid, and there are like 3 sides, they're all equally important. So I said, first of all, that my child should never be in the care and custody of strangers. And we do that through our custody and guardianship planning. And we said that our child is going to need support even after I'm no longer able to provide it through incapacity or death. And so we have to talk about how am I going to transfer assets to my child so that they have what they need when I'm no longer able to provide it. And then third, we said that they should never involuntarily lose eligibility for benefits. And we do that through protecting those assets for them. And you guys, I'm sure most of you have heard about supplemental needs trust, or sometimes called special needs trust. A lot of you may have ABLE accounts and you may be guardians of your children, but these are the three sides of this pyramid that, when they all are together and complete, really gives us as parents the peace of mind that we're looking for. So I want to start off with that first agreement. It says, my child will never end up in the care of or home of strangers. And so the question becomes, so what happens? Who will take care of your child if something should happen to you and your partner or the other parent of your child, or if you're a single parent of a child with a disability? So there are two areas here that we have to talk about. One is short term. And I guess what I like to say is, like, just put yourself in this position where you and your partner, your spouse, have set aside a date. You found someone to sit with your child that you trusted to sit with them, and you're going to go out and just get a little bit of alone time. And the worst possible scenario happens, and you don't make it home. Who would have legal authority to take immediate custody of your child? And there's, I don't know if you guys, even have an answer to that. A lot of people tell me, well, my parents would take them. Well, the question here is, who would have legal authority? And as you guys may know, that decision often rests with the DCS worker who shows up and says, you got a minor child at home, both parents are in the hospital, or they're not coming back. And so the state has a duty to ensure that your child is safe and in a safe environment and taken care of. And the state has that final decision to say who is appropriate. And so, assuming that your sibling or your parents or some other family member is automatically going to be able to take your child in during that time is not necessarily accurate. And so this is where one of the first places where your child could end up in the home and care of strangers. And so, a very quick story. Just a few years ago, this kid named Alex. He and his parents were on the highway. And well, actually, he was with his dad. They were involved in an accident, and his dad was killed in the accident. And Alex was 7 years old. And he was also injured. He was in the hospital. He was in critical condition, but he didn't have any immediate family members available for him. And his parents were divorced, and his mom was actually going through some really serious personal health issues of her own, and lived in another state, and she wasn't able to be there for him. And so the court appointed a guardian ad litem for Alex. And this is, again, a stranger to make sure that Alex was properly seen to and cared for. So, this eventually worked out where the one of the family members who lived in another state was able to come in and petition for guardianship of Alex and take him home. But in that time period of, I think it was about 6 weeks, Alex was under the care of the state. And there were, until this family member was able to get the court-appointed guardianship, there was no one there that his dad or mother would have preferred for him to make sure that he was not being cared for by a stranger. So I know this is something that, like I said, it was one of the big things with me, and I was very worried about it when my son was younger. And I know so many families that I talked to about have this same concern. And so we're going to talk about how to deal with this in just a moment, but just understand that without the proper legal documentation, the people that you want and expect to take care of your child if anything ever happens to you may not be the ones that end up doing it. So having that proper legal documentation in place is critical for that. Then we have to talk about long-term. Now we're getting into permanent guardianship. And again, here, if you don't have the proper documentation in place, nominating guardians for your children, if you never make it home, it becomes really kind of up to the courts. And anyone with an interest in your child can petition to become guardian, even competing interests. And, for example, just another quick story. A few years ago, I think it was the Berber family was traveling through Arizona. They were from California, and they were involved in an accident. Both mom and dad were killed, and they had 3 children. Now, the children did not have special needs, but just to kind of illustrate the point, again, these 3 children became wards of the state of Arizona, and a search went out to try to find a family member to become their guardians and to take them in for the rest of their lives. And it ended up being a big fight over 2 sisters. One of them, it became clear during the court proceedings, was really after the money. And because there was a lot of money associated with the care of these kids, and if she took the kids, she would get the money. And the other sister was really about the kids. They didn't really care about the money. And so well over $100,000 was spent just in legal fees fighting over these kids. And it ultimately came down to the court's decision as to who got them. So again, a very simple legal document saying, that in the event that I'm not able to be there for my child, I nominate this person to be my guardian. And more often than not, the courts will honor that, and they will honor your wishes to make sure that the right people are in place to care for your child in the long term. And so how we plan for this, we call this our Kids Protection Plan. And it's basically a 9-step process that we go through to make sure that your kids never end up in the home or care of strangers, no matter what happens to you as their parents. So I'm going to go through those 9 steps very quickly. The first thing we do is we take our clients through the process of choosing the right long-term guardians. And a lot of parents are like, well, it should be their older brother or older sister, or it should be this person, or, well, I don't want my sister to have to take them. She just doesn't have any money. And we take our clients through a 3-step process to choose the right guardians based on non-emotional decision-making, and really kind of basing it around values and how you want your children raised and where you want them raised. Then we prepare the legal documents to make sure that all of that is captured and ready to be presented to the court if needed. The next step we could do in this is choosing short-term guardians. In the interim, when before the courts, it's a 60 to 90-day process to get guardianship. And so what happens to your child in that time period? So we make sure we have the right people chosen to be short-term guardians. And these are usually family, friends, pastors, teachers, neighbors, people who can get to your child within about 20 minutes with proper legal documentation to let law enforcement or DCS workers know that they have legal authority to take custody of your child. So we capture all that in the right legal documents. That's the 4th step. We give your short-term guardian nominees the proper legal documentation for them to always have on hand. And we also notify your caregivers in schools of who these people are, and we give them instructions on what to do if law enforcement, for example, shows up at school and says, Billy's mom and dad have been in an accident, and I need to take Billy and put him in custody. The schools and caregivers have specific instructions on what to do in that situation. One of the things that we also do is we give our parents a family emergency ID card, and it says on that card, I have minor children at home, and if something happens to me, please call these people, and the people that you've nominated to be your short-term guardians are the first to be called. And it says, I do not want my child placed in the care of DCS or placed in a stranger's home. I want these people who have legal authority to take custody of my child to be notified. So the seventh step in all of this is we communicate with all the potential long-term guardians. We tell them what to do if they find out that anything has happened to you as the parents, and we give them instructions either to call our law firm or where to find the proper documents if they need them. Sometimes long-term guardians have to fly in from out of state or make other arrangements, and so that can take a little while, but we know that we're covered with the short-term custodial guardians while the long-term guardians get into place. Now, number 8 is really important. We have numerous clients who will tell us, you know what, my child's biological father or my child's biological mother, they're not fit to raise a kid. They are addicted to meth, or they're serving a term in prison for child abuse. And they can't ever be, they can't ever take over my children if something happens to me. But they have the biological parent, and I'm afraid the court will give them priority because of the biological parent. And so we actually have a process in place where we can advise the court of why this person should not ever have custody of the child or be a guardian of the child in a way that is secure and private, and won't cause any strife in the family if they should find out about it, because they won't find out about it unless they some point in the future do petition for guardianship. And then the final step that we deal with our clients is, do you have enough financial resources for your guardians to care for your children? And we do that through life insurance, savings, retirement plans, and there are so many options available now for affordable life insurance that even our parents who sometimes have limited cash flow are able to get a sufficient life insurance policy, so that if, for example, the sister who would be the perfect guardian for your child but can't afford to feed another person in their household, if that's the person you want, you can take that burden away by saying, not only will you become the guardian of my child or my children, but here's the money that you need to make that possible. So that's, I think, a really critical part in this. And before I move on, I want to just kind of remind everybody, this is true for your children with autism, but it's true for all your children, neurotypical or otherwise. If you have minor children at home, the thought of them being, I'm sure, in the care or home of a stranger is I'm sure terrifying to you as well. And so there is a process you can go through to make sure that does not happen. I'm seeing some specific questions in the chat. I'm going to wait on that question just for a moment. It might be answered in the next slide. If not, let's talk about it at the end. So the question comes up. That's great, John. We're talking about making sure my minor children never end up in the care or homes of strangers. If something should happen to me or to us as the parents. But I have adult children. What about them? And so I'm not going to go through all of these questions, but these are very common questions that we get about guardianship. What is it, for one thing? What's involved in it? What do I have to do? Is it right for me? Is it the right choice? If it is the right choice, when should I petition the court for guardianship? If it's not, should it be me or should it be somebody else? What's expected in the process, et cetera. So I'm not going to answer all these questions, but I am going to hit a couple of them. So the first one is, what is guardianship? So in Arizona, we break up guardianship and conservatorship into two different areas. Guardianship is the responsibility and control over the person, and the conservatorship is responsibility and control over the finances. And so what we find is that a lot of our parents' children don't have any finances. They're not able to work, and they don't have any money per se, other than their SSI or other benefits. And so most of our parents just go for guardianship. And so guardianship is a legal process. It allows you or whoever is chosen to make medical, education, housing, social decisions on behalf of another person who is unable to make those decisions for themselves. And we always try to find the type of guardianship that allows the family member to have maximum independence, because full guardianship removes all civil rights basically for your adult child. And we have a lot of adult children who need some level of guardianship, but who are otherwise independent. And so in Arizona specifically, we can do a limited guardianship, and we can tell the court exactly, we just need guardianship in these specific areas. For example, just for medical decision making, or just for whatever the case may be. So the other question that comes up, is guardianship the right choice for my family member? And these are some of the questions and some that we ask families and we explore with people, is, does your family member need protection from any kind of abuse or exploitation? If so, they might need a guardian. Is your family member unable to give informed consent for medical decision making? I just spoke with a family yesterday, beautiful 26-year-old daughter with Down syndrome. And they were telling me, they're not guardians of their daughter, but she had to have a medical procedure a couple of years ago, and the hospital gave them, a really hard time about her being able to give consent. And fortunately for them, the powers that be made an exception and allowed the parents to go ahead and give consent for her, even though they don't have guardianship. That's not always the case, and more frequently is not the case. And so if your child is unable to give informed consent, at some point, if they need some kind of medical intervention, you may find yourself in a situation where your child can't give consent and you don't have the authority to give consent. So we ask, can they understand or agree the terms of the contract? Can they manage their own finances? That type of thing. So these are some of the processes that we go through with parents and helping them make this decision. The other question comes up, when should I do it? In Arizona, you can apply for guardianship for your child at age 17 and a half. And the benefit of this is when they turn 18, everything is behind you, all the court process is behind you, and you can go ahead and get that guardianship on their 18th birthday and not have any lapse in coverage. When is the right time? Anytime you recognize the need. And for some parents, it's like, why are you waiting? Do it now. All right. So, if this raises any questions, guys, throw them in the chat, and I will try to address them before we leave. And also, if I'm going too fast for you, I'm kind of talking fast. There's a lot of information. If there's anything that I went over too fast and you say wait a minute, I didn't catch that, throw that in the chat, and I'll try to go back and clarify for you before we leave. So we talked about the kids protection plan, making sure your kids never end up in the care of strangers. But if you remember on my pyramid, the next question was, how will you transfer the assets to your children? And this goes to that second fundamental agreement that we talked on early on. It says, my child will need additional financial support when I become incapacitated or die. And that support is going to come through you transferring your assets to your child. And this is what I see a lot. Parents will say, I don't understand what the big deal is, John. I have a will, and I've left assets to my child in my will. You know, what's the problem? Why isn't that okay? And so my answer to this, first of all, a will is only effective upon your death. If you become incapacitated, your will does not in any way help your child have access to resources. If you leave your child with more than $2,000, it can disqualify them from state and federal benefits. You guys are probably well aware of that. Additionally, your child might be somewhat vulnerable, and anything that they receive, legal judgments and things like that. Very often when I look at people's wills, they don't name a guardian or conservator for their child in the event of their death. And so, you know, we have lots of families who come to me in their later years. Their child is in their 40s, lives at home with them, and they're beginning to realize that their child might outlive them. They need to make arrangements. And so they'll go online and do a will, or they'll buy a will package. And these will packages and these online things, they don't give you the option of appointing or nominating a guardian for your child. And then what I never see is a will that provides specific instructions on how to care for your child with special needs. And so, is a will enough? Absolutely not. And we'll kind of talk about a couple of reasons why that is. First of all, whether you have a will or you don't have a will, the only way to transfer assets to your children is through probate. And well, I should say most commonly, the only way to do it is through probate. There are some exceptions. We'll talk about a couple of those as well. But in Arizona, probate, we're considered a probate-friendly state. There's nothing friendly about probate. We're looking at least 12 to 18 months on an average family. There's attorney's fees, there's court fees, there's appraisal fees, sometimes there are bond premiums, there are creditors knocking at the door, and it can easily cost anywhere, we estimate, on average, for an average family with a home and a car and some money in the bank, somewhere between $3,500 to $5,000 to go through probate. But during that time, your child and any other children do not have access to all of your assets. There's a small allowance that's allowed during the probate process, not enough to take care of your family. And so when you think about, you know, probate is, it's, you know, like I say, whether you have a will or don't have a will, it's going through the court process to ensure that your creditors are paid first and anything left over is distributed to your children or other beneficiaries. If you don't have a will, Arizona has written a will for you, and it's written in statute. And so the what that means is that everything you have will be given to your children equally, and the state doesn't care if your child is 11 or 40. The state does not care if your child has any kind of special needs or is dependent on benefits. They're going to inherit an equal share with their siblings outright. And so, you know, obviously this raises, you know, concerns about their eligibility for benefits. The only difference between having a will and not having a will is that if you don't have a will, everything goes to your children equally. If you do have a will, you have the option of telling the court how you want your assets distributed. Other than that, it's the same process. So even without the financial cost, somebody has to be in charge of your probate process. We call that a personal representative. And a lot of people come see me because They'll say, you know what, my mom, my dad just died. I was the personal representative of their estate, and it was horrible. I just got it finished, and I don't want my children to have to go through that. And so, aside from the financial cost, there is a true cost in time, energy, and attention for your personal representative. So. The other thing that happens in a probate type situation, whether you have a will or don't have a will, is that at age 18, your children will receive your assets. At 18, your child is an adult. And we have, clients come to us that, maybe they're still young, they don't have a lot of cash flow, they don't have a lot of assets yet, but recognizing that they've invested heavily in life insurance. And so, in the event of their passing, their child could easily inherit $1 million in life insurance. And if they're 15, 16 years old when parents die, at age 18, they will get that $1 million. And so I know it's like being 18. And boy, if I had gotten $1 million when I was 18, I would have done very stupid things with it. And I think most of your kids will do the same. Even more importantly, though, if you have a child with special needs and they inherit that money at age 18 or any time after, first of all, they're immediately going to lose benefits. And benefits isn't all about money. A lot of it is about job opportunity and training and things that is difficult to purchase with money. And so that type of inheritance can immediately disqualify your child from any of the help that they would receive. So here are some of the mistakes people make when I talk to them and say, yeah, John, I get it, but let me tell you what I've done. Sally's sister, Susie, has agreed that I'm going to leave everything to Susie, and Susie will take care of Sally for the rest of her life. That way, Sally doesn't have any money. Sally won't lose her benefits. And Susie has assured me that she'll take care of her. Sounds great on paper, but there are so many risks involved in this. There are, depending on the type of asset, the sibling could end up owing all kinds of income taxes for the year that they inherit. If the sibling should get divorced, the entire inheritance could get caught up in the divorce proceedings, and half of it go to the ex spouse or the divorcing spouse as part of the community property estate. So everything you thought you left for your child is now in your other child's ex-spouse's hands. There's a couple of examples. Other people said, well, I've disinherited my child, again, for the same reasons. There are all kinds of risks associated with that. Other people said, you know what, we're not going to put our kids through probate because we have created beneficiary deeds for our house. We have beneficiary designations on all of our life insurance. And so there won't be any probate. Everything's going to go through beneficiary designations. Again, the same problems. If your child with special needs inherits from a beneficiary designation, true, they've avoided probate, but now they have assets that will disqualify them from benefits. If you leave everything to the care of another sibling, the same situation arises. One of the probably more common errors that I see is just parents ignoring the reality that they have to do this planning, and ultimately failing to plan at all. For many people, it feels overwhelming. It's too expensive. I don't have people in my life to name to take care of my children. So they bury their head in the sand and they don't deal with it. And my mission is to help people understand that there is a way forward. There are ways to get around those objections, and there is a way to get that plan in place, despite your misgivings and your fears. So if leaving everything to my child in a will, or if I don't have a will, if that's not ideal for my child, what should I do? And I'm going to tell you right now, the only foolproof way to avoid these these traps and these pitfalls is through a living trust. And I'm not here to sell trust. I believe in them when it's appropriate. I would definitely recommend them, and I work with families to create them. But they're not right for everybody. So again, that's why in our 2-hour special needs planning session, my job is to educate and inform the clients so that they make a decision that's right for their family based on coming from a state of empowerment. However, you should understand that if you have a child with special needs and you want to protect those assets for that child and preserve their benefits, a fully funded living trust is really the only way to ensure that. And what I mean by that is that not that you have a trust, not that you've done a special needs trust, but that you have transferred every asset that you own into that trust appropriately, and that you have named proper beneficiaries for life insurance policies and for retirement plans and all of your other assets. It's the only way it works. And if you don't do that correctly, you can really cause harm to your child, and you can involuntarily have their benefits suspended. And so let me just check my notes here. Let me make sure I'm covering everything. Yeah, so this is probably like people will come to me and say, "Hey, John, I've written a trust, or I went to another attorney to write a trust. Can you take a look at it and tell me if it's okay?" The first question I ask them before I ever even open the document is, "Have you transferred assets into your trust?" And so many times they get a glazed look on their eyes and they're like, "I'm not sure what you mean." And there's my answer. So getting your home, your business, your personal property, your bank accounts, all of that transferred into the trust is the only way to ensure that those assets will pass to your children, whether they have special needs or not, without probate and quickly and privately, without having to worry about scammers and other people taking advantage of your children. So, some of you guys may have seen this, if you've done some like the trust packages, or if you've gone online, or if you've talked to an estate planning attorney. And that's, again, the critical thing is that it has to be fully funded, and all your assets have to be properly titled. So that takes us to the third agreement, which is that my child should never involuntarily lose eligibility for benefits. And how do we do that? Well, the first thing is that by placing those assets in a special needs trust, they are available to your child, but your child does not have control over them, and therefore they are not counted as a resource for your child. And the federal and state government have done an excellent job of writing legislation around this to allow us to provide for our children and still maintain their benefits. However, getting those assets into that special needs trust is most efficiently accomplished coming through your own revocable trust. So as a parent, you set up a revocable trust, and then you create a special needs trust for your child, and those assets will flow seamlessly into that special needs trust. No gap in coverage for your child, no gap in availability of resources, and no threat of losing eligibility for benefits. So, you can, in a special needs trust, you can set up conditions for how you want those assets managed for your child. You can do so many things, such as placing certain types of resources in your child's special needs trust. For example, you can have an investment account or brokerage account in your child's special needs trust. It's growing in their trust so that it's available when they need it. You can have businesses, homes, cars, personal property, all of that can reside in your child's special needs trust. and be managed for your child while still preserving eligibility for benefits. Those resources are also protected. So it's an asset protection trust, meaning that the courts cannot reach those. If your child does something that causes harm to another person and gets sued, the courts cannot go into that special needs trust and say you have to pay damages out of that. It's protected. If your child is able to get married and then divorced, those assets cannot get caught up in that divorce and go to that ex-spouse. I think even probably most importantly is you get to know that what you want for your child will be carried out. There's the resources and the instructions in that trust to ensure that the lifestyle you want, the life you want for your child is available to them. And so you can always know that they're going to have the quality of life that you want for them. I do see some comments in the chat. I'm not ignoring them. I am going to get to those in just a moment. So that's kind of where this ends for today. Now, I've only talked about a few aspects of special needs planning. We've talked about making sure your minor children, whether they have a special need or they're neurotypical, whatever the situation, they never end up in the homes of strangers. We've talked about what to do with your adult child if they need guardianship and what that means and how to go about that. We've talked about making sure that because your child will outlive you, most likely, that you're able to pass assets to your child in a way that avoids probate, avoids the delays and expenses, and ensures that they have continuous access to resources. And by putting them in a special needs trust, you can ensure that they will be available for them and they can maintain their government benefit eligibility. So again, these are kind of like hitting the high points in those three areas. There's so much more to talk about, and I wish we had all the time. We don't. So just a quick reminder, this is my family. This is why I do it. The reason you're here today participating in this because you have a family, you care about them, and I know that, and I hope, I trust that the information I've been able to give you today will help bring some clarity to the next step and hopefully some motivation to say, you know what, we just need to get this done. So you don't have to do it alone. You have three options. One, you can take this information and say, thank you, John, this was very good, and walk away and do nothing. You can say, John, thanks for this. You've given me great direction. I'm going to go online. I'm going to go get a kit. I'm going to do it myself. Or you can work with an attorney. And I can tell you, I went option 2. I did it myself. And it was a long, hard journey. I applaud you if you can do it. I encourage you to work with an attorney, and I encourage you to not work with just any asset or estate planning attorney. Work with someone who understands special needs planning, who has dedicated themselves to the study and mastery of special needs planning. I've seen too many plans created by people who don't really focus on this, and they don't work for the families. So, I would love to have the opportunity to work with you. You may choose to work with somebody else. That's great, but please find somebody that you connect with that has the skill set to do what you need to get done correctly. So if you do want to talk to us, there's two options. You can just talk to one of my staff members. 15-minute phone call, doesn't cost you anything. Or if you want to work with me, you can schedule your free special needs planning session with me. And it's a 2-hour session. It's free, and we will make sure that you're fully educated, informed, and empowered, and make sure your questions about your family are addressed. So here's how you get a hold of us. The number's on the screen, 520-428-1188. Or you can just email us at hello@terabellalaw.com. If you're interested in some of the kids protection planning, we actually have a website you can go to directly, and you can get started on getting a kids protection plan set up for your kids, and that is free to start that process. All right, so I'm going to take some questions. Kate, are we okay on time for a few minutes?
Yeah, we can stay, I can stay on with you, so if people are good to stay, they can, or it'll be recorded if anybody needs to go, so you can catch up later. So there are a couple
Okay.
questions in this chat. I don't know if you want to read them or if you want me to read them to you either way.
Well, let's just take a quick look. Boy, I missed a few of those. I'm just going to start at the top, but that's okay. My daughter is nonverbal and has autism. We already have a special needs trust in place and are planning to establish guardianship. Do we also need conservatorship, or is guardianship sufficient in our situation? I'm hoping that what I talked about was sufficient. More often than not, guardianship is sufficient. If your daughter has her own resources, if she's inherited from somebody else, or if she has assets of her own in any way, then you might consider conservatorship. Do both parents need to be co-petitioners when filing for guardianship, or is it sufficient for just one person? We see both. Sometimes we have just one parent who goes for guardianship. More often than not, both parents go in as co-guardians. That provides continuity if one of the parents gets ill or is out of the country. There's a guardian available for their child, but there is no law specifying one way or the other. So transferring assets to the living or SSI trust and designating my, S&T trust, a special needs trust, and designating my daughter as the beneficiary, will this impact her SSI benefits? So if your daughter is reliant on SSI benefits, and you place assets into a special needs trust for her and she is the beneficiary, as long as she is not the trustee, and as long as she does not have any control at all over those assets and is purely a beneficiary, and as long as the trustee has full discretion in whether or not to distribute any assets to your daughter or for the care of your daughter, it will not affect her benefits. However, you should know that Social Security Administration does sometimes audit these trusts, and if they find anything in there that indicates that your daughter has any control, or if the trustee does not have full discretion, if there's an automatic distribution to your child, they can disqualify her. Okay, so Phyllis said, thank you, John. This is helpful. We did a lot of what you said, setting up will and special needs trust, but your talk reminded me of more what ifs I need to think about. Thanks, Phyllis. That's encouraging. That's what I hope to do is get people thinking. All right, I think that's all the questions. Kate, do you have anything else?
Nope, that was it. Thank you so much. This was such amazing information. Really appreciate you talking to us today.
It is